All right, it looks like we are up and running for our final hearing. We've had some technical difficulties this morning. Hopefully we can make it through this last case okay. Our final case on the docket this morning is from Johnson County. It's number 123-827. It's entitled "In the Matter of the Licensure of Shelly and Vandevord Daycare Home." And who do we have here for the appellant?
May it please the court, Amory Levin on behalf of Kansas Department of Health and Environment.
And for the appellee?
Thank you, Your Honors. May it please the court, Sean Edwards on behalf of Shelly Ann Vandevord Daycare Home.
All right, counsel, as I said earlier, remind you that we have read your briefs. We're familiar with the facts of your case and what the issues are. You might keep that in mind as you make your argument during the limited amount of time that you have to do that. In this case, each party is given 20 minutes for your argument. You don't need to use it all, but you're granted that amount of time if you want to do that. After your case after we hear the arguments this morning, your case will be deemed submitted for decision. And after that, we will take the case under advisement and get a written decision out to you and your clients just as soon as we possibly can. Ms. Levin, we will begin with your argument. Let me ask you, do you wish to reserve any time for rebuttal?
Yes, Your Honor, 5 minutes, please.
That is granted, and you may begin whenever you're ready to proceed.
Thank you, Your Honor. Yes, so this case is an administrative agency action case.
Can I interrupt you with just one? I'm sorry. One final interruption. There is a jurisdictional issue in this case that we will ask the parties to definitely be addressing that as well. Go ahead and proceed.
Yes, thank you. And I was going to start there. If you all want me to go into any of the facts during any of my argument, just say the word. But I do think whether jurisdiction exists, first of all, is a question of law, and that's going to be unlimited review on the Court of Appeals part. I do not think I put that in my supplemental brief, but that was in the cases that I submitted as additional authority. The Travelers Casualty versus Corns case has that. I mean, and there are several other cases that also have that. But so I think starting there with the jurisdiction issue, I do think the Court of Appeals has jurisdiction. And so this was a remand. And as I laid out in my briefs, most remands are declined when they're appealed because they're not a final appealable order. In this situation, this remand was, our position is unlawful because the district court judge did not follow the Kansas Judicial Review Act. And so because we have an unlawful order, that does give this court jurisdiction. And so we certainly want this court to address that. We want you to address the underlying appeal, which is the court did not follow the Kansas Judicial Review Act. And
well, how come every time a judge remands back for additional fact finding, which is what we have here, it seems to me that the party in your position could always just say, oh, that's unlawful, therefore we do have jurisdiction. I'm not really seeing how you're distinguishing this case from the other case law that we have that's squarely on point, that's saying if the district court remands for additional fact findings, that's not a final appealable order.
Well, so let me try my best to distinguish that for you. So in those other cases that I listed, and I'm sure you have reviewed, in almost all of them, there was something that was not done. Whether that was, it was remanded for some type of further hearing, some type of proceeding, that was not done. And that's why the remand wasn't taken up on appeal, because they had to complete that. In this case, this was a final complete case that came to district court. There wasn't any other fact finding to be done. The record clearly demonstrates that through the hearing that was had at Office of Administrative Hearings. So this.
What was unlawful about our district judge saying, you know, a year and a half has gone by. Why don't you go inspect the facility one more time?
Well, so what was unlawful about it is, first, he had to go through the KJRA, what is laid out. And so if he would have done that, then perhaps he still would have came to the same conclusion. But first he had to go through and determine whether there was substantial evidence that supported the decision, which he got in the initial order, which was adopted as the final order. And because he didn't go through those steps, he handed to the agency, and he didn't remand it for further proceedings, which is what the KJRA says. He just, as he says, simply remanded it to the agency. He, I believe, wanted us to do another survey, but as you can see in the transcript of that proceeding, it was a little confusing about what he was wanting. If he would have gone through the KJRA, my position would be he would never get to the point where he would say it was unreasonable, because he would see that there was substantial competent evidence supporting the findings of fact and conclusions of law that were in the initial order. So I believe he wouldn't even have gotten there, but I feel like he got sidetracked.
Well, how is, excuse me, how is the order illegal if he has the authority under 77-622B to order a remand back to the agency?
Well, I think looking at 77-622, that he can remand it for further proceedings, which is different. And maybe this is a minute difference, but that's something different than what he ordered. What he ordered was something that's in the agency's discretion, which is to do a survey, when to do a survey, when those are warranted. That's not what he did. He didn't give us any other direction on how to follow up, even if we would have gone out and completed this survey. So he got a final case, and then not following the law, it's like he's opening it back up, making it non-final, when that should not be allowed because he didn't follow the Kansas Judicial Review Act. So hopefully that answers that question under 77-622B, is that he can remand the matter for further proceedings, and that's not what was done in this case. But before.
Well, I guess how is for further proceedings when the order says the agency's to do another inspection of her home, given the fact it had been what, 18 months since one had been done?
So, well, first of all, that's not a proceeding. So a survey is not a proceeding, Judge. That's where the agency goes out to check for violations of rules and regulations of the actual daycare, and that is not a proceeding. But also, I did want to address this time frame issue. So the appellee, she was the appellant at district court, kept arguing that there had been too much time had gone by, but this was a final case, and it did take longer than normal because of COVID. So what happened was they filed initially a notice of intent to suspend and modify her daycare license, which they were going to change it from a group daycare home to just a regular daycare home, because that allows less children present, because her biggest problem was she continued to be over her license capacity. And I don't mean just one child. I mean, sometimes it was 6 kids, sometimes it was 3 kids, sometimes it was 2. She just continued to be over capacity. And this went on starting in March of 2018 through April of 2019. And the agency kept trying to work with her. And most of this came out in the testimony at OAH. The agency continued to try to work with her to get her into compliance, and she just continued being over capacity and had safe sleep violations. In those first 6 surveys that were done during that time frame of 2018 and 2019, she had 38 separate violations. And counsel might argue that some of those were not important, but they're all important. And most of our daycare homes don't have violations. So any violation is important. Those rules and regulations are there for a reason. So anyway, so then we filed the notice of intent to suspend and modify. And as is usually done at this time, I was not the attorney on the case, so I'm not sure, but I assume they were considering working out a consent agreement with her. And so they go back out to do further surveys to make sure they're in compliance. And that's why there were 2 surveys done in April, and she was not in compliance. Both times, again, she was over capacity. And something else I wanted to point out is one of the times she was over capacity, 2 kids crawled out from behind chairs in the living room. And those children, she was already talking to the surveyors, and those children had not been accounted for by Miss Vandevord. So she had either lost track of the number of children that she actually had in her home, or she was just lying to the surveyors. And in either case, that is not okay. So we do have some egregious behavior here. It's not just a matter of, she was over a kid or 2. This was a consistent problem. And I believe in her testimony at OAH, she said that she only stopped doing that after Mr. Edwards she hired him and he told her to stop that. And so I don't think she, for whatever reason, understood. But so her final survey was April 30th of 2019. And shortly after that period of time, then KDHE filed a motion to amend the notice that had already been appealed to a notice to revoke. And that is when I believe she hired Mr. Edwards. He got in, he filed a responsive pleading to that, opposing to it being amended, but the administrative law judge did decide to amend that to a notice to revoke. And then because Mr. Edwards had just got involved, I think they did take some time to allow for discovery. The hearing was set, I think January 9th and 10th of 2020. And so in that big scheme of things, the time frame is not that long. And I just want the court to be aware that if there had been a complaint, surveyors would have gone out there. It wasn't like she was, we were like, oh, we would never go out there for any reason after we do our final survey and file, enforcement action. That's not the situation. But I do think it's important to keep in mind that, so then the hearing is set in January, they have a hearing, and then of course, I think in February or March, then, the world shuts down because of COVID-19. And so the initial order, which was drafted by the administrative law judge, did not come out until I think it was late June of 2020, and the hearing, keep in mind, had been in January of 2020. And so then the case gets appealed to district court, and unbeknownst to me, I think surveyors did go out there and do a survey, but I was not aware of it. So I do think at the time that the court was so concerned, there had been surveyors out there, but I'm not sure because during COVID, they were not doing their regular surveys. So that was something under the governor's orders that they weren't doing. So only if there was a complaint, or something else raised an alarm, were they going out and doing surveys. That's not normal. And so I do think that's important to take into consideration. It wasn't like the agency was just, derelict in their duties. And so then once the district court case was pending, the judge, the other party filed a motion for stay, and the judge did grant that stay, and he ordered us to renew the license. Now, when he granted that stay, he did not, again, follow what he should have under the KJRA. He didn't use the right language. But at the time, KDHE, I was aware of that, but that didn't seem that important. Maybe that was a red flag that I didn't pay enough attention to. But anyway, so Judge Power issued the stay, ordered us to renew her license. And then at that time, her next annual review date, they did go out and do another survey. She had violations again, not over capacity, but she had 6 violations. So, but I do think it's important that, that should not be the focus of this. The focus of this should be that the district court did not follow the law. Very clear. And so I think that's, where obviously I want you to focus on, because if we have district courts that agencies can't rely on, that they're going to follow the law, I'm not even sure what we're doing here.
So counsel, your contention is that the district court was not permitted to ask you to do a new survey, but that after it was final, after your decision was final, but that you do additional surveys after final decisions if you just determine they're necessary.
I'm sorry, Judge, my timer's going off.
That's all right.
Apparently it won't let me stop it. So I'm sorry, the contention was that
Your contention is that the district court did not have authority to order you to perform another survey after your final decision, but that you, as an agency on your own, do in fact do additional surveys after the final decision if you determine they're necessary.
well, there's certain stipulations in the statutes, reasons the agency has to go out and reasons the agency can go out. We just don't randomly go out to people's home and
Right,
to check.
right.
So if he would have, so under the KJRA, if he would have followed that, there is a provision where I think before final disposition, he could have ordered us to go out there, to conduct further fact finding and other proceedings. That's under 77-619. So I think if he wanted to follow that and order that, he could have, but I still, even before we get there, I still think he has to go through the scope of review under the KJRA to get to that point where he can consider, so he didn't make a ruling on whether he was going to consider the other evidence, whether he's going to allow a new issue. He didn't go through whether under 77-621B, where it says, the court shall make a separate and distinct ruling on each material issue on which the court's decision is based. And if he would have done that, this would be, maybe we wouldn't even be here. I'm not sure, because he didn't do that.
All right, counsel, you have used you're going into your rebuttal time. So if you still want to reserve that, we'll need to turn it over
Yes.
to, all right.
We'll stop.
Thank you, Your Honor. I'm sorry.
Yeah, I'm
Go.
sorry, counsel, you can begin whenever you're ready to proceed.
Thank you, Judge. Judge, I've got a lot I want to say about Mrs. Vandevord, but I want to touch on a couple of things that were raised in argument just a moment ago and clarify some things. Is there just some misinformation that's been provided to the court here? Judge Halber found their action unreasonably, put it in his order. They don't like it. And so they're here trying to argue that he didn't say it or didn't say it right. He found their actions unreasonable and told them what to do to go fix their unreasonable actions. That's the order we're here on today. Counsel has argued that my client, Mrs. Vandevord, who, by the way, has been running a business in Johnson County for 30 years with a virtually spotless record, that she was continuously, that's the words of counsel, continuously over capacity from October 18 to April 19. That is a misstatement of the facts. Mrs. Vandevord had an occasion where she was over capacity back in 2018. It was remedied in conversation with KDHE without a citation. It was just taken care of. The parties put their heads together and remedied the situation. Mrs. Vandevord remained in compliance up until this citation in March of the next year. What happened in March of the next year? She had a family friend that was in a dire situation. The grandfather had fallen ill, who was watching the children, and against her better judgment, she took in these two children, knowing it would put her over. Mrs. Vandevord is mortified by that decision and does not wish all of these proceedings on anyone in her position. She wishes she could take it back. She made a mistake. She's accounted for that mistake, both to the district court and to the administrative law judge. They're seeking the death penalty for her 30-year business for an error, and an error that has not only been corrected, but has been consistently corrected for the last 3 years. She has not had a single citation. Counsel has also misstated that at the time that Judge Halber heard this case, that they had been out to review her. Judge Halber heard this in January of 2021, issued his order in February of 2021. At that time, Judge Halber told them, go out there and do another review. They waited from February until August to go out and review Mrs. Vandevord's property again. So for counsel to tell this court today that, yeah, I think we had a survey and we did a survey, no. They waited 7 months after Judge Halber told them to do it, to go out for one survey. And let's talk about that survey. Counsel a moment ago alluded that there were citations, that there were deficiencies found in that, and that's wrong. There were no citations made and no deficiencies in Mrs. Vandevord's daycare in August of 2021. She has had a clean record from the moment that she cleared this problem up through today. And she's had that same clean record for the last 3 decades, with the exception of the hiccup we're talking about today. Mrs. Vandevord makes no bones about the fact that she made a mistake. She's accounted for that mistake. She wishes to be accountable from KDHE for that mistake, but that mistake should not be the death penalty for her business. It's not. It's as Judge Halber said, that's unreasonable. Let me talk a little bit about Mrs. Vandevord's daycare. As I said, she's been in business in Johnson County, serving Johnson County residents for the last almost 30 years. For the majority of those 30 years, she has had an absolutely spotless record. Her clients rave about her. They count on her. Generations of them count on her. She's an important fixture in her community.
Counsel?
Yeah.
Tell me, do you believe that this is a final order from the court on remand, or do you?
Thank you, Judge. Yes, I don't believe it is, because I think Judge Halber anticipated that they have further work to do. Judge Halber took a look at what they did, said in his order that it was unreasonable, and had an expectation that they would go back out and do what KDHE generally does. And we'll talk about that in a moment. In a typical year, KDHE has over 22,000 citations, and that could be everything from a dirty dish in a sink to something very dire. Okay, that's what citations are. So when counsel says, we had 38 citations, I mean, literally one of those citations was they didn't like the fitted sheets she was using. So that was a citation. That's certainly not grounds to give her 30-year business the death penalty. But I digress. Your question about jurisdiction. No, I don't think so, Judge, because I think Judge Halber had an anticipation that this agency would go back and correct the direction they were taking this case. And but ultimately, Judge, from Mrs. Vandevord's position, she's been dragged through this for 3 years by this agency. This isn't a lucrative business she's in. We're of the position, we'd like the shortest distance to the end of this matter so that Mrs. Vandevord could get back to work. If that means that this court hears it, so be it. If that means that Judge Halber hears it, so be it. in either case, the actions of KDHE were unreasonable in this case. This doesn't warrant stripping her of her livelihood that she's had for 30 years.
Well, counsel, if this was a non-final order by the district judge, then we don't have appellate jurisdiction.
I understand that, Judge, and you've heard arguments both ways. Our brief, the position we've taken is that Judge Halbert did not issue a final order and that he expected KDHE to follow up appropriately. It took him 7 months to follow his order, but that's our position. And you've heard the opposite position from KDHE. Quite frankly, we're interested in resolution of this matter for Mrs. Vandevord. Does that answer your question, Your Honor?
Thank you.
Thank you. If I could touch for a moment on the evidence that Judge Halbert did listen to, and this is important. KDHE's own records from 2015 to 2020, it's a 6,510 page spreadsheet consisting of over 113,000 citations that KDHE issues to the various daycare providers throughout the state over that 5-year period. It breaks down to an average of about 22,000 citations from KDHE to daycare providers in the state each year. In the year 2020, out of those over 22,000 citations, KDHE revoked the licenses of only 3 providers. And all of those were egregious situations where they were physically abusing or actively endangering children. And all of those were immediate revocations.
Well, counsel, I guess I have a hard time understanding the relevance of some act by KDHE after the fact involving other people than this particular case, when the administrative law judge and the district judge was supposed to be looking at the acts and the investigation.
Judge, he looks at the acts and the investigation, but he is also empowered under the law to use his discretion to determine how does KDHE generally handle these kind of cases. That's exactly what he looked at here. He looked at the 5-year period from 2015 to 2020. And importantly, in that time frame, in those 5 years, there were 24 other daycares that were also cited for having over census, having too many children in care. All 24 of those were permitted to correct the error and remain in business. Only Mrs. Vandevord has been singled out by KDHE for disparate treatment. Every other case, all 24 other ones in those 5 years, were given the opportunity to correct the error and keep their license. And that's our point here. That's what's the point we want to drive home. This Mrs. Vandevord stands ready and willing to do exactly what they asked her to do. From the outset, they asked her to correct the deficiencies. They've been corrected and corrected for the last 3 years. They asked her to attend some prescribed training courses. She attended all of the prescribed training courses. They asked her to update her sleep policy, the safe sleep policy. She did so. They asked her to pay a civil penalty of $1,000. She stood ready to do so. They never gave her the opportunity to write that check. They switched this to a revocation. She stands ready, willing, and able to comply in the same way that her peers have complied over the last 5 years. And our position simply is that it's too far of a reach, and Judge Halbert agreed with this. It's unreasonable to strip this woman of her livelihood when she's complied with what they've asked. She's fixed the problem. No one's been hurt, and she's remained in compliance, not only since then, but looking back the last 3 decades, other than that window of time where she had an issue, she has a clean bill of health. And so what we argued to Judge Halbert and what he considered in looking at how KDHE adjudicates these matters, he concluded and agreed with us that their actions were unreasonable. He sent them back. He said, go take another look at this. Go look at her daycare and make a determination that way. And that was his order. But he definitely could have said, yes, your action in stripping her license from her is reasonable. Case closed. He didn't say that. He said their actions were unreasonable and sent them back to do what they've done for her peers in this situation.
Counsel, let me interrupt you with a question here, because I might be wrong on the facts, but I thought there was something in the briefing that might have indicated that KDHE has been out there to re-inspect or resurvey, whatever the word is, while this appeal has been pending. I'm not sure if I don't think that that's reflected in our record, but it's mentioned in the briefs. And I guess I'll at least ask you to elaborate on that.
Certainly, Your Honor. Judge Halber ordered them on February 1st to go out and inspect. They waited until August, I believe, the 14th. So they waited, what, 6 months or so before they went back out. But yes, there has been exactly one visit to Mrs. Vandevord's daycare since March of 2019.
This would be August of 2021.
Since May of 2019. Yes, August of 2021, correct. So May of 19 to August of 2021, there's been one inspection.
What are we to make of that, though? I mean, how do we deal with that as the court if that's not in our record?
Well, Judge, it wasn't before Judge Halber, because it happened after the fact. It happened after his order came out 6 months after his order. So we could certainly supplement the record to reflect. I mean, or you can take judicial notice of it. I assume, Your Honor, it's an official act of a state agency. I'm sorry.
No, I'm finished.
Oh, okay. Thank
Mr. Edwards,
Yes.
it appears you're making an argument that she should be given another chance at rehabilitating her license, fixing the problems, etc. But it is my understanding that the action didn't start as a license revocation action. It started in a manner to allow her to fix it, but then those fixes did not occur.
Your Honor, I can address that.
Okay.
It started out on March the 20th of 2019 as a citation with instruction for remedying the situation. They asked her to correct the deficiencies. You're correct. They asked her to attend some training courses. They asked her to update her policy. And they asked her to pay a civil penalty. She attended the courses. She updated her policy. And then here's where the error comes in. Mrs. Vandevord had these family friends, and they were in the lurch. Grandfather was watching the children. I know grandfather was injured. I believe grandfather may have died. I don't recall specifically.
Okay.
Yeah.
So, Mr. Edwards, you were talking about the 24 other instances in which the agency did not revoke under similar situations, but were they actually similar? Was there another violation after the initial notice?
Judge, I don't know the specifics of all 24 of those. I do know that in every instance, a person was given an opportunity to correct the issue. In this instance, Mrs. Vandevord absolutely acknowledges that she let another 30 days go by without correcting this issue. She did that, and we've acknowledged that at every level. We've acknowledged that to the ALJ. We've acknowledged that to the district court. Our position remains she did remedy it. There have been no further violations for the last 3 years. Her record before that speaks for itself for decades where she didn't have this issue. So this isn't the recidivist that KDHE wants to paint here. This is someone who made a mistake. And I'll compare this, if I could, for a moment to our profession. We're all lawyers here. And God forbid one of us ends up in front of the disciplinary folks. And the driving force behind the disciplinary matters for lawyers in this state is to get them back to work, unless they've committed a serious crime. Obviously, we don't let criminals keep their license. But there's even an entire branch of the disciplinary committee dedicated to rehabilitation of lawyers who get themselves into trouble. The goal is, let's keep people working. Let's not shut down businesses over things like this. Let's get people back to work. And that's exactly what Mrs. Vandevord has done. She's towed the line and she's back to work, and she's been there for 3 years, and she was there decades before that. I want to remind the court one other thing too. At any time that KDHE deemed Mrs. Vandevord too dangerous to remain open, they had the power under the statute to issue an immediate suspension of her license. If they believe that she was a danger to the community and should not retain a license to run a daycare, they could have stopped her in her tracks with an emergency order. They never did that. They never issued an emergency order here because, quite frankly, the fact of the matter is they knew it wouldn't stand up. It didn't have enough in their arsenal to say that she's unfit to be doing this job. So the juxtaposition of this situation where here they stand before this court saying she's unfit to be a daycare provider, yet on the same token, they've never pursued their power. They're the people they're the agency that's empowered to do that, to put a stop to her right now. That just highlights the fact that this isn't a situation where we ought to be stripping her license from her, or we ought to take away her livelihood and close a business in Johnson County. That's not what we ought to be doing here. And Judge Hauber agreed with us. He said it's unreasonable. Go back and survey her and let's get her back to work. That's our position. Would appreciate the court's assistance in wrapping this up for Mrs. Vandevord. Litigation's expensive. She's fighting against the government. They've got unlimited coffers. She does not. We'd like to get this resolved for Mrs. Vandevord. We'd like to get her back to work and get this off her plate. And if that's Judge Hauber's decision or this court's decision, we'll leave that in your hands, but we would certainly appreciate the assistance in doing so. Thank you.
All right, Ms. Lovin, we will turn to your rebuttal time. Let me just start off with a question here. I know as a judge, I probably should be more focused on the law, but I can't help but to just ignore the practicalities of a case. Is the agency just digging in their heels here and just insisting on shutting this daycare center down? Or I'm trying to get around the fact that all the judge wanted you to do was survey the place one more time. And you said you would do that if there had been a complaint. And why didn't that get done?
So Judge, again, I do feel like precious time is being wasted on issues that are not or should not be in front of the court. The issue isn't, should she have had another survey after the final agency action? KJRA directs everyone to look at what occurred at the time of the agency action. What did the agency consider? And so the agency is not digging in their heels, but we are trying to follow the law. And I think it's really important. And I appreciate that Mr. Edwards is being a zealous advocate for his client. But we still have to follow the law, and sometimes that hurts. And we have to follow it so there's order. We have to follow it so the agency knows how to proceed in future cases. And in this particular case, what I want to refer to the court to is to the record. Because Mr. Edwards started out his argument saying that I had misled the court, and that is not true. It wasn't true in district court, and it's not true here. And so I want to refer you to volume 5 of the record. And it is a little confusing because they put the certification of the record. So they put the certification, which lists out all the records in volume 5, in volume 4. So to look at volume 4, pages 49 through 52 is where you have the certification of the record that lays out all the documents that were in the record from OAH. And the record from OAH is volume 5. So, but you can look at the notice of intent to suspend and modify the daycare license. That is page 1 through 9 of volume 5. And then you can also look at the notice to revoke, the notice of intent to revoke. That is pages, I believe, 47 through 55. And what you will see is that Mr. Edwards is just wrong, because those notices lay out every survey and every violation. So if you want to see what really happened between March of 2018 and April of 2019, go to the notice of intent to revoke. It's all in that one. And what it will show you is she had multiple violations. And Mr. Edwards might think that the fitted sheet is not a big deal, but that's considered a safe sleep violation. In care, it is a big deal, because when the sheets aren't fitted on the crib correctly and they get bunched up in a baby's face, they can suffocate. And so it is an important violation, which most of the violations are. They're there for a reason. So anyway, I hope I somewhat answered your question. We are not.
Well, you did. You got about a minute left, and I'll occupy it with question. My colleagues can ask a question too if they want, but does this whole appeal boil down to whether or not we can find any lawful authority or any legal reason that granted the judge authority to remand this back for an additional survey? Have I oversimplified the case too much, or does
Well, let me make sure
does everything boil down to that?
Well, I think what it boils down to is the unlawfulness, so that the judge not following the KJRA.
All right, and so even if we say that, even if we conclude, judge, that was unlawful, all we do at this point is remand the case back to the judge and say,
No.
you decide this based upon the record that was before you, right?
No, you do not have to remand it. There's an abundant case law that this court can sit in the same position as district court. So if you decide to overturn the judge's remand order, and you find that, you know, he did not follow the law, you can look at the case with fresh eyes, because you're under the KJRA too. You follow the same law.
We can be fact finders?
No, you're not fact finders. That's already been done. So that was done running up to the hearing at OAH. So the last facts were the final survey, which was April 30th of 2019. So all the facts, the finding of fact and conclusions of law are all in that initial order.
We'd have to go back to the ALJ's order, right? That's what you're saying? then?
Right, that was adopted
Okay.
as the final order.
All
And,
right.
and that is also in the record. That is in volume 5, and it's at page 141, and it's a 10-page document, but it is very thorough. And if you haven't had a chance to review it, I would urge you to. I would hope that in closing, you'd give me just a minute or two. I did want to ask you that if you do find this was unlawful and that you do have jurisdiction, that when you look at it, that you go through and you can see under 77-617, this court took in a new issue. The law is very limited as to when they can do that. The district court did not follow the law there. Under 77-618, review and disputed facts. I want to point out that there are not disputed facts. The appellant, Miss Vandevord, was not disputing any of the facts in this case. Under 77-619, additional evidence. Again, the KJRA is very specific about when the courts can get into that. And then most importantly, the scope of review, which is 77-621. And I do want to point out that there are several steps there, and it is very limiting to the district court. And I can understand maybe that's frustrating for them, but they can't just put in their opinion. They don't really have very much discretion. They have to follow the KJRA. And if he goes through and makes particular findings, and then he finds we're unreasonable under, I think, 621, let me make sure I give you the right statute, 621C8. I do want to point out that C8 says the agency action is otherwise unreasonable, arbitrary, or capricious. And that otherwise means he first has to go through the law and he has to follow that. And if we have substantial competent evidence and didn't violate her constitutional rights, he has to uphold that decision. And I know that that can be frustrating, and maybe he doesn't think it's fair, but he doesn't get to put in his decision for the agency's decision. And I did want to point out real quick, there's an older case. Mr. Edwards keeps bringing up these other cases after the fact, which I think should not even be considered, because there were cases that were revoked in 2019 when Ms. Vandevord's was revoked. There were, I think, 6 other cases revoked. But regardless, in Pork Motel, Kansas Department, Park Motel versus Kansas Department of Health and Environment, I think the site on that is, let me see if I can find it here real quick. 673P second 1126. I'm sorry, I don't have the Supreme Court site on that, but it talks about selective enforcement in there. And it says the Supreme Court of the United States has said that failure to proceed against all alleged violators of the law does not preclude an administrative agency from enforcing the law against one violator. And they're citing a case called Moog Industries Incorporated versus FTC in that case. And so even though Mr. Edwards wants to argue that there were all these other cases, which I don't think should be considered to begin with, we could still do that. That's not unlawful on the agency's part.
Council, I've let you go over 3 or 4 minutes, actually, so we do need to wrap
Thank
this
you.
up.
Thank you, Judge, and I hope none of you think it's inappropriate for me to end with Rock Chalk Jayhawk Go KU.
I'll second that.
I think we're unanimous in that. Maybe the only thing we can agree on.
Great, thank you.
All
Thank
right,
you, Judge.
Council,
Thank you,
thank you
Thank you.
for your briefs and your arguments. We appreciate everything. And with that,